So welcome to term 2 discussions. We shall be looking through family law practice. So basically here we have term 2 module 3 succession, estate planning, probate, and letters of administration. So basically this workshop you must understand where do we get letters of probate and where do we get letters of administration. So it's very, very important to understand that you only get letters of probate when a person left a valid will. So where a person has left a valid will, you can apply to get letters of probate. But where a person does not leave a valid will, then we say that he died intestate, and you can apply to get letters of administration. So it's very, very important from the very beginning to understand under what circumstances do you apply for letters of probate, and what circumstances do you apply for letters of administration. So I'm saying that I only apply for letters of probate if a person did not leave a valid will. But if a person left a valid will, you apply for letters of probate. But if a person did not leave a valid will, you apply for letters of administration. So the first matter dealt with marriage, separation, and dissolution of marriage. The second matter dealt with matters of children. The third matter is succession, estate planning, probate, and letters of administration. This model introduces you to the practical aspects of estate planning, testacy, intestacy. So the importance and relevance of this model cannot be underscored. The disadvantages of intestacy are obvious, and yet a will alone, although valid, may not always be adequate to estate planning. So some people always leave a will whereby they bequeath all their properties, but others always don't bequeath their properties in a will. So the value of estate planning cannot be overemphasized because fraud is a way of life today. Administration of estates of the deceased cannot be trusted to work in the best interests of the beneficiaries of the estates which they manage. Many of them do not even know that they are trustees and they are accountable to the beneficiaries of these estates. So it is important to understand that once you have been appointed as an executor, or maybe given letters of probate or letters of administration, the property of the deceased does not become yours, but you are just a mere trustee to pass over the property to the beneficiaries. So the courts have dealt with a very big number of cases involving negligence, waste, fraudulent dealings, and mismanagement of estates of deceased people, and yet the courts can only do so much: uphold caveats and revoke grants. Judgments and decisions of court will not always ensure recovery of property stolen or wasted or lost. Therefore, it is the beneficiaries of these estates who stand to lose. The situation is terrible where the beneficiaries are children or dependent people like the elderly and incapacitated people. They need to provide for security one's estate, the livelihood of one's children, and dependents after one demise or disability, or that even that a person goes missing requires intentional planning for one's property and affairs. Estate planning, this can be achieved by using the strategy of a will or trust or both. So basically I've said that it's very, very important that you bequeath your property in a valid will, because if you have not bequeathed your property in a valid will, then that means the administrator general has to come in to manage your property. So this can be achieved by using strategy of a will or a trust. A vast business empire or polygamous family may not be adequately planned for by simply writing a valid will, even if it creates a testamentary trust. So we understand that a will is defined as a testamentary document which bequeaths the property of the person upon his demise. So a will is a testamentary document which bequeaths the property of a person upon his demise. So whereas you should know the principles of law on testacy and intestacy, and also learn the skills of preparing a valid will, obtaining probate and letters of administration, and protecting these estates as well as the interests of the beneficiaries of these estates, it is imperative that you learn the skills of estate planning. You should know what estate planning is, the principles of law on intestacy, testacy, wills and trusts, and be able to apply this knowledge at each unique case, and accordingly effectively advise people on how they should plan for their property for the benefit of the beneficiaries and the security of their estates, as well as welfare of their loved ones and dependents. So in this module, we'll learn how to prepare a valid will, how to obtain probate and letters of administration, and how to structure a will on the one hand and a trust deed on the other. For purposes of estate planning, a will or trust deed prepared to achieve the objectives of estate planning must be carefully and strategically prepared so as to be able to deal with your client's unique situation, simple or complex. So basically, we have how you are supposed to prepare a will under the Successions Act. We even see that the Successions Act gives us a format which you can adopt for you to make a valid will. But it's very, very important to understand that for us to have a valid will, it must be in writing, and at least it must have at least 2 witnesses. So that's why it's very, very important for us to understand when do we have a valid will. So you will learn how to protect estates so that seized and the rights of the beneficiaries thereof, lodging a caveat against an application for probate or letters of administration, and taking all the necessary practical steps that are incidental to lodging such a caveat. So you will also be able to prepare, present, and prosecute an application for probate or letters of administration, or one for probate receiving. So basically, when we talk about application for probate, it means that the person died with a valid will. Whereas when we talk about letters of administration, it means that the person did not die with a valid will, or what we can call intestacy. So when you are intestate, or when you don't die with a valid will, we apply for what we call letters of administration. So this module covers the following: 1, principles of law relating to estate planning, testacy, and intestacy. So basically, testacy, it means the person had a valid will. Intestacy means the person did not have a valid will. So also look at preparing a valid will, and we are saying that the Successions Act provides that for us to have a valid will, it must be in writing, and it must be attested by at least 2 persons. Structuring a will for purposes of estate planning. So you must bequeath property in your will which basically belongs to you. You can't bequeath a property which is not yours in your will. Then structuring a trust deed for purposes of estate planning. So we shall also look at trust deed and how do you draft one for purposes of bequeathing your estate. We have looked at the trust deed before, I think, in land. So now we're going to also look at it in family, but basically means the same thing. And you understand the case of NIT versus NIT, that the court stated for us to have a valid will, there must be first to have a valid trust, there must be proper intention, there must be a certainty of purpose, certainty of objectives, and also a certainty of intention. So nature of estates of the dead testacy and intestacy, determining beneficiaries of the estates of the dead and the rights of these beneficiaries. So we can see that the Successions Act gives us several beneficiaries. They include linear descendants, they include children, they include elderly people like mother and father, as long as we are being cared of by the deceased. Then the procedure and practice of obtaining probate and letters of administration, high court and subordinate courts. So we shall look at how do you basically obtain letters of administration from the High Court and the Chief Magistrate's courts. Then presenting and prosecuting a petition for probate or letters of administration or probate receiving. So basically, when we talk about probate receiving, we mean situations, for example, where you get letters of administration from Kenya, and then the property is in Uganda. So that's the process we call as probate receiving. You have letters of administration from Kenya, but the property you are going to be managing is in Uganda. So the procedure for lodging a caveat upon an application for probate or letters of administration. So whenever you want to lodge a caveat on property, what you do is that you have to lodge a caveat, and the caveat is always in a prescribed form. For example, if someone has applied for letters of administration, they have to put a notice. They have to put a notice of the application. So in case you have any objections, you can lodge a caveat against the application for probate letters of administration. Suits arising out of caveat lodged upon an application for probate letters of administration. So so once there is a caveat, then the matter can be the matter goes to proceed as a suit by ordinary print. Then defenses suits arising out of a caveat lodged upon an application for probate or letters of administration, the procedure for probate receiving, drafting all relevant legal documents such as a will, trust deed for the objectives of estate planning, then a petition for probate, a petition for letters of administration, a caveat be lodged against the petition for probate, letters of administration, and relevant court documents. Then shall also look at extracting and enforcing relevant court orders. So the statutes, we have the Successions Act and the Administrator General's Act. Most importantly, we have the probate receiving rules. We have wills. Of course, in the case of Sarah Nabagara versus Joyce Naku, a will was defined as a testamentary document which bequeaths the property of the deceased. So what a testator can and cannot bequeath, in Reverend James Chamukama and another versus Catherine Zarbwenda, you can only bequeath property which belongs to you. So you cannot bequeath a property which is not yours. Beneficiaries, meaning and determinants. In the case of Stella Maris versus Esther Nabsakara, the court is saying that beneficiaries are those who have been who the deceased have been caring for. So we can have, they could be parents, they could be children, linear descendants, all those ones who are under the care of the deceased. Nature of office and powers of administrators or executors. Remember, the power of the executors or administrators is basically to manage the estate and also help in transferring this property to their own beneficiaries. Powers of joint administrators, Silva Biarhanga versus Emmanuel Rundeja. They must act together to administer the estate of the deceased. Suppose having separated from the intestate. So once you have died, once a person dies, when you are separated, you are not always entitled to the properties. Then looking at caveats, you can lodge caveats to object to the grant of the letters of administration or probate. Administration pendulite. Administration pendulite always arises in situations where you find that the letters are being revoked, and during that time court can appoint an administrator of the estate. Extension of validity of a probate or letters of administration. Extension of validity of probate or letters of administration. We have the case of an application for renewal letters of administration in respect of the estate of the late Ndaba Kwata. So basically, this one means you can extend time of validity of probate, for example, or letters of administration. Then extension of time within which to file an inventory. An inventory arises in situations, for example, you must file an inventory within 6 months as the administrator of the estate, and also a final account after 12 years. So an inventory is always filed after 6 months. It basically involves the property of the deceased, and then after 12 months you have to file what we call a final account, basically showing how you distributed the property of the deceased. Disputes relating to burial of the deceased. Basically here if there is a conflicts about the body of the deceased, always we first look at the will, because in most wills people speak about where they would want to be buried, but if there is no anything to the same in the will, then we shall always follow customary law. Then trusts, we shall look at creation of trusts in family, but basically they are like the ones that we looked at in land. So learning aims: advise the principles of law on estate planning, advise the principles of law on probate and letters of administration, demonstrate ability to structure wills and trusts as tools for estate planning, and develop ability to obtain probate and letters of administration, and organize the ISCO issues relating to estate planning. So the ISCO issues include: one, you have to also put into the best interest principle of the child into account. You also have to consider how do you apply for letters of administration or probate by being honest and not by fraud. Then lawyers are not overcharging clients and also not acting without instructions. Those ESCO issues have been looking at. So we look at workshop 1. By the end of the workshop, we should be able to explain the principles of law on intestacy, determine the estate of an intestate, the beneficiaries thereof, and their rights. Remember, in the case of Kabari versus Kajubi, the court stated that even children who are out of wedlock are entitled to the estate of the deceased. Demonstrate the procedure and practice of obtaining letters of administration. So letters of administration can be obtained where the person died and did not leave a will. So basically, you have to call a meeting, take minutes of the meeting, get a certificate of no objection from the Administrator General, and then you proceed to apply for letters of administration. Demonstrate the procedure of lodging a caveat upon an application for probate or letters of administration. So once you want to lodge a caveat, you must lodge this caveat at the court that issued the notice of application, and then you must serve this caveat to the applicant. Demonstrate the procedure for probate receiving. So basically, you have to apply to the registrar attaching the letters of administration, and then they can seal those letters. Draft all the relevant legal documents. We shall be looking at petitions, and also identify and appropriately deal with ESCO issues that may arise in these areas of practice. So summary of Jane Sima's interview statement. My name is Jane Sime. I live at Nsonde in Wakiso district. I'm here with my son Kenneth Mukisa. Kenneth is 25 years old. My husband Lukan Simbi died on 22nd August 2023 when his car collided with another. My husband and I had 3 children. They are Maria Ntendo, aged 15, Luka Miti, aged 19, and Kenneth Mukisa Miti is a student at Mbara University of Science and Technology. Tendo is a senior C at Nabingo College. Kenneth Mukisa is married. My husband paid bride price for me in 1998. I hail from Ushenyi district. My husband married Margaret Birungi at Namenembe Kasido in 1990. My late husband and Margaret Birungi were not blessed with any child. My husband was blessed with 3 children before that he wedded Margaret Birungi. They are Jonah Mugaga, age 28, and Fortunate Margaret Nunji, age 25. Fortunate are married and have homes of their own. The third was called Simon Mukisa, who died in 2020. Simon Mukisa left a child called Simon Sitende. My husband told me that he raised Samari Berawa from age of 4 when she was abandoned at All Saints and Souls Church. I came with a bag which contains very many valuable documents, including marriage certificate showing that he wedded Margaret Birungi. My husband left the following property: a residence house at Kauku and Tebe Road, a residence house at Sonde Wakiso, a maize mill on 1 acre of land at Abeta Wabiri, 5 acres of land, a modern commercial building, a plot of land at Namugongo, and 10 acres of land at Ruero, Bukarasa Broke 230, plot 120. So identify the property which constitutes the estate of the local Simbi, deceased, the beneficiaries of the said estate and their rights. So basically, when you identify this property, you look at only that property which is vested in the names of the deceased. The properties which, for example, is matrimonial home, that one cannot be bequeathed, and also where is you only have to give out property that only belongs to him. So what additional information and evidence do you need in order to effectively advise the beneficiaries of the estate on how to manage this estate roughly? So basically here what we are saying is that this person, he died with no will. So if this person died with no will, that means shall be applying for letters of administration. So the additional information, one is first and foremost, how many beneficiaries do you have? Did the person leave a valid will? Secondly, did you have an executor? So information like that. Then assume that you have obtained relevant information, draft the necessary legal documents which will enable you to obtain the instruments for managing this estate lawfully. So basically here what we are looking at, you have to draft a petition because petition for letters of administration because we have no evidence to any will. Then they explain the steps, procedure, and practice of obtaining the requisite grant. So basically, when you're for letters of administration, you have to call a family meeting, record minutes of the meeting, all beneficiaries attend the meeting. Then after that, you have to get a certificate of no objection from the Administrator General, and then after getting a certificate of no objection, you can proceed to apply for letters of administration. Then after having made application, the court issues a notice, and if there's no caveat lodged, then the court can proceed to give you letters of administration. My name is Serena Nainkabo. I'm 48 years old. My brother, the late Simon Kakwire, died in January 2023. I had 3 children, Doris Kakire, Waisa Kakire, and Tinywa Kakire, aged 25 and 20 respectively. Doris is independent. Waisa is a student of computer science at Mbara University, and Tinywa is a student of law at Maka University. I have bought a photocopy of the document which the High Court gave me. Refer the document labeled SCN. So when you look at that CN document, we can see that CN is basically is CN CN are letters of administration. You can see CN are letters of administration. So this person has given letters of administration. We can see CN. This person was given letters of administration. So there is so much I have not done. I must sue the man who obtained a forged special state title over my brother's land, which is at Mbare, Kayunga, my brother estate in dubious ways, and was registered as the owner of this land. I'm glad I have obtained all the evidence which I need, and I can now confidently sue this thief. It has taken me over 6 months to assemble this evidence. They very well know all these matters, and they would like me to recover this property and money. So I applied for certified copies of the records on the court file in respect of the matter disclosed in the document labeled SCN, and established that Naikoba has not submitted to court an inventory of the said estate. Advise Naikoba on the steps which she must take in order to ensure that she recovers the money and the land necessary legal documents. So basically, how you have to apply to file an inventory out of time. We have to apply to file an inventory out of time because the inventory has not been filed, and that one we have it's always a notice of motion supported by an affidavit. So see, I'm Musa Musango. I'm 60 years old. I live at Kayebwe, Masaka district. When I was reading today's Wikiday's new paper, I was extremely shocked to learn of the notice at page 15 showing that a man whom I do not know and I have never met applied for sort of the High Court over my son's property. My only child, Zachary and Sim Mugaga, died in the sleep in 2021. He was only child. My wife and I live with his children. The man who had his notice published in this newspaper is not his son. I don't know him, and I have never met him. I do not know where he obtained my son's passport photograph from. See copy of the notice document labeled M1. So when you look at M1, basically M1 is notice of application of letters of notice of application of the letters of it's a notice of application of the letters of administration. So M1, so they are saying that M1, which must have provided, visit the appropriate court registry and obtain the document labeled M1. I am worried about my safety and about my son's property. My son Zakari Simbi Mugaga owned the following: 1 acre of land at Lunguja, 1 square mile of land at Bugere, and 17 acres of land at Kayabwe. My wife Nina Musango and I live with our late son's children. They are Alan, Adam, and Simbi. You verified Mr. Musango's claim, and using the information in the document which Mr. provided, he visited the appropriate court registry and obtained the document labeled M2. What practical steps will you take in the interim on Mr. Musango's? That basically is you have to lodge a caveat. You have to lodge a caveat, draw necessary legal documents. Where will you file these documents? So basically, you first have to lodge the caveat, and basically the documents would be the caveat and an affidavit in support. Then it's now 3 months. So also then after that you also have to bring a plaint. So it's now 3 months since you took the steps in D1 above. You have confirmed that the petitioner in M2 has not taken any steps in the matter. What further steps would you take on Musango's behalf to necessary legal documents? So this one now becomes the plaint. You have to issue a plaint as the person who lodged that caveat. Then from here we have, supposing in the estate of Zakari and Sim Mugaga seized in see above where instead was 40 million Uganda shillings, what practical steps would you take in order to protect your state? So basically I have to lodge caveats in the magistrate's courts. You have to lodge caveats in the magistrate's courts. So the important documents here would be caveats in the magistrate's courts. E. Festus Kamoa was a Kenyan. He was the proprietor of MS White Nile Guinea Limited, and he ran these businesses on a 30-acre piece of land which is in Ngoje district. He had leased this land from a Ugandan called Munyuka. The remaining term of this lease is 45 years. On 14/1/2025, the High Court of Kenya granted Nina Wamunyu, widow of Festus Kamua, probate in respect of the SSL of Festus Kamua, YD High Court Probate and Administrative Cause number 2 of 2025. Nina Wamunyu seeks your advice on what she should do in order to lawfully manage the above business. Explain to her the procedure and necessary documents. So basically here you have to go through the process of probate proceeding, and when you are doing this probate proceeding, just have to apply to the registrar, attach the copy of the letters of administration, pay the necessary fees, and then they will have that letters of administration resealed, which basically allows you to manage property here in Uganda. So you can look at the under the probate proceeding rules. Workshop 2. By the end of this workshop, you should be able to explain the principles of relating testacy and estate planning, determine the essence of the intending testator and the beneficiaries thereof, demonstrate how a will or trust or both can be used for estate planning. So basically here we are looking at a person who died with a will, demonstrate the procedure and practice of obtaining probate, and when a person died with a will, that basically means that we are applying for probate. Then draft all the relevant legal documents, present and prosecute a petition for probate, identify and appropriately deal with issues that may arise. So facts, Miss Kenyan Ntuyo's interview. I'm Karen Ntuyo. I have been working as an air hostess, but I retired last March on health grounds. I'm suffering from breast cancer and going through 4th stage of this cancer. No therapy will save me. My children are Lona Basima, Suzette Mukisa, Lena Sintendo, and Isaac Rwanzi. Their father died 2 years ago. Lona is a student at Mbara University of Science and Technology. She's married. Suzette Mukisa is in senior 3 at Nadia High School. The others are in primary school. I would like to advise on how best to ensure the well-being of my children and parents so they do not suffer after my death. We have a milk processing at Mubende, practice crop and animal husbandry. I also manage an ultra-modern hatchery, 30 acres of land at Ntanda, Metiana district, 10 acres of land at Nsumbe, land at Bukerere, 5 acres of and at Tizigo in Wikwe district, and an ultra-modern 4-bedroom. Money on my bank accounts, 50 shares in Denzel Cream Limited, 4 acres of land at Nsingo, and 1 acre of land at Namugongo, land at Ntinda, among others. My 86-year-old father is suffering from dementia. I spend a total of 3 million shillings per month on drugs and services of a male nurse. I live with and look after my mother. I'm also fully responsible for Pad and Sozi. I would like to ensure that on my death, none of these people is prejudiced and their needs are fully met. My children and nephew must have a very good education and their welfare should never be compromised. After my death, I would like to responsible and honest people, my brother Nixon Taro and my sister, to hold and manage selected properties, land at Ntinda, at modern and proper grocery, Bukoto, Delight, Bukoto guest house, and the farm. I trust my brother Nixon Taro and my sister. They are also the kind of people who can ensure that whatever I state in my will is done. So basically, you can see in the last part, the last part here we can have to create a trust, and the first properties we can create a will. So here they are saying that advise Mr. Zamba on what constitutes Karen and Tuyo's estate. So basically when you're advising on what constitutes estate, you look at only property that belongs to that seized. You don't look at matrimonial property, you don't look at joint owned property, you don't look at the property owned by the company, but you look at only his property. Advise Mr. Zambo on all the practical steps which Kenya should take in order to ensure that after her death, her dependents' welfare will be assured. Here we have to draft a will properly witnessed by 2 witnesses. Prepare checklist of the information you require from Karen to you in order to effectively advise her on the practical steps. So basically here, you want information as who are your beneficiaries, which properties do you have any other property, who do you want to be the executor of your will, like that. Then assume that Karen died having executed a valid will and that this is will names her brother Nixon Taro and her sister as the executor of the will. Advise Mr. Zembo the steps which her relatives should take in order to ensure that her estate is managed lawfully. So basically here above we have drafted a will and also a trust deed. Then here on the process of applying for letters of probate, basically you have to call a family meeting, record minutes, then you continue to apply for letters of probate in the appropriate court. Here you don't need a certificate of no objection from the Administrator General, because when the person leaves a valid will. So assume that Ken died having a valid will. Advise Mr. Simba on the steps which relatives should have to take. Draft the relevant legal documents, which is the petition for probate, which is like the ones we drafted for letters of administration, but this one is for probate. Therefore, there must be a valid will attached. In Ken Tuyo's will E above, she did not make any provisions for the maintenance of or any benefit for the biological daughter Suzette Mukisa, because she was dismissed from Nadia High School for using prohibited drugs and having been provided to be 2 months pregnant. Advise Mr. Zamba on the legality of this position, the remedies, if any, available to Suzette Mukisa, and how you would obtain the same, and what are the necessary legal documents. So basically here what we are looking at is that once this person was not included in the will, it's very, very important to understand that your parents have no duty to leave you property in a will, but if they have not given you property in the will, they must give reasons why they are not giving you any property. So basically here, what you can do is that you can apply for maintenance, and the procedure would be notice of motion supported by an affidavit, and that arises where you find, for example, that the person was not included in a will. That's when you can apply for maintenance, and by using notice of motion supported by an affidavit. So basically that was it for workshop 2, and in case you want a mastermind group where we give notes to students, we also answer all the past IAs for the last intake, for the first intake. We also give a brief summary of the cases. You can WhatsApp me on the number on the profile, and then we can add in that mastermind group where students pay 100,000 per month to support our research. So workshop 3, we also guide you through the mood, and basically how to go about the mood, and we can also get you documents of the first intake regarding the same mode. So learning outcomes: by the end of this month, you should be able to draft pleadings for a suit arising out of a caveat lodged on an application for probate or letters of administration, present and prosecute a suit arising out of caveat lodged on an application for probate or letters of administration, present and prosecute a defense to the suit arising out of a caveat lodged on application, and then recognize and deal with ESCO issues arising for that case. So here what you have to understand is that we shall be dealing with caveats. If a person now lodges a caveat, because for that caveat to be removed, you have to proceed by using a plaint to basically remove that caveat. So basically that will be the center for this mood, where we shall be proceeding by a plaint. So my name is Merab Ankunda. I'm 48 years old. I live at Chamuragan in Barra City. I'm the biological mother of Asimwe, who died on 7th. My daughter had 2 children, and Maria Twine. They are twins. I have been living with these children since the year 2019, which Dick Uyumba married their mother. Dick and Rosina were blessed with 1 child, Rena Blessing, who is now 3 years old. Dick lives with Rena and his other 5 children. Dick has applied to the High Court for authority to manage my daughter's property. I have read the notice of this application in today's or tomorrow newspaper. I do not trust Dick. I took after my grandchildren. I know that my daughter maintained a savings account with Housing Construction Bank Mbarara, and there is a balance of 50 million. So here basically we have facts for Dick Bukayana. We have motor document number 1, which is a petition for letters of administration. We also have motor document number 2, which is a declaration, and we also have notice of application of the letters of administration, and then we also have petition for letters of grant of probate and letters of administration. So basically what is going to be happening in this mode is that we shall be proceeding by a plaint to remove a caveat which has been instituted which has been instituted by a person opposing to grant letters of probate administration. So that will be the mood. And please, I wish you a blessed week. That's all we had for this analysis. But in case you want more detailed information, you can come to me in my inbox. And basically, if you want to join our mastermind group, you can come into my inbox, and then if you make the necessary payments, we can make you part of that group. So please, this is term 2. Remember, term 2 we do modes which are marked. We also have IAs which are marked. So please take it very seriously. Please subscribe, like, share, and comment, and put on the notification button so as you don't miss any updates, because we promise you, we started with you this journey at LDC, and we promise you to take you up to the very end. Please have a blessed week and a very happy term 2. We remain the Pass the Bar team.